Okay. Jefferson County Court at law number 2 is back in session. The court is in session in 2 cases. There are cause numbers 24 CCCR 0826 and cause number 24 CCCR 0827. Both cases are styled the state of Texas versus Jaden A. Riley. Mr. Riley, is that your full name? Mr. Riley, would you please raise your right hand? Mr. Riley, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Riley, you may put your hand down. How are you doing, Mr. Riley? That's good. Now, Mr. Riley, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Riley, do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant? And are these your initials on the line that state you waive your right to an attorney and you wish to represent yourself? On the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial, do you recognize this document? And is this your signature on the line that's titled Defendant? Mr. Riley, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Riley, I also have a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Riley, it alleges that you, Jaden A. Riley, on or about February 28th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Riley, do you understand what you have been charged with? And to this charge, Mr. Riley, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Mr. Riley, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this same document, there's a set of initials. There are 2 sets of initials. The first set of initials, JR, is on a line next to a box that says check guilty. Did you place your initials on this document? The second set of initials is below a paragraph that is titled Discovery Admonishments, and it is on line next to a statement that reads, I do not request discovery of the evidence. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature? Now, Mr. Riley, the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? Is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that is checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Riley, before you sign and initial all of these documents that I just showed you, did you read these documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Riley, are you a citizen of the United States? State?
046-1.
Mr. Riley, state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is the first document that I showed you on this tablet. This is the same document that have your initials, that has your initials in these 2 locations. This document also has your signature above the line that is titled Defendant. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case? No objections. State's exhibit number 1 will be admitted. Now, Mr. Riley, is there any evidence that you are currently mentally incompetent to stand trial? Okay, none. Mr. Riley, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is to 90 days probated over 1 year with a $500 fine and 40 hours community service. In exchange for this plea agreement, the state is dismissing cause number 24 CCCR 0826.
Oh, no, they didn't write it on
You can do that real quick.
yeah, she didn't write where it was being dismissed. Here you go.
Thank you, Judge.
What is the score cost?
277.
Okay. Mr. Raleigh, the state is offering that you serve 90 days in the Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you will be required to pay a fine of $500, court costs of $277, probation fee of $60 a month, your analysis fee, $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $154 a month. Will you be able to pay the $154 each month?
I don't think I'll be able.
Okay, do we have an affidavit on him? Okay. Yeah, you're gonna have to take a seat at that. Or you should be able to. Give me that, reach that to me.
Okay.
Oh, this is in Spanish.
Here's.
Okay, now on this document, see what I have, just highlighted. You're gonna fill that information out, this information out, and there's another one right here, I think. Okay, fill out those boxes if you receive any benefits. You should be able to do that. You can stand right there and do it. Should be able to do that in about. Okay, now, Mr. Raleigh, I have before me a document that's titled Affidavit of Indigence. You recognize this document? Now, before you sign this document, did you read it? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Raleigh, the court is gonna find you to be indigent, and based on the finding of indigency, the fine and court costs totaling $777 will be converted to 62 hours of community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. And the reimbursement fee of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. Now, the court costs in this case, not the court costs, but the probation fee in this case will be reduced to the statutory minimum of $25 a month. So your total monthly installments that you will be required to pay, now you'll be required to pay the reimbursement fee, not the reimbursement fee, but the analysis fee of $15 a month. Now your total monthly installments will be $44 a month. You'll be able to pay the $44 each month. You will also be required to perform 40 hours of community service in addition to the 62 hours that was converted from fine and cost, which comes to a total of 102 hours. The state will be dismissing cause number 24 CCCR 0826 as part of this plea bargaining agreement, and you will be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Riley, do you understand the state's offer? You think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Mr. Riley, I will follow the plea bargaining agreement with the adjustments that have been made in your case. Please have a seat in the gallery. Wait for your name to be called. Once your name is called, you'll be free to go and you have a blessed day. Hmm? Yeah, 102. Thank you. Now we have y'all have the motions here? Is that correct? Pre-trial motion here?
Yes. Yes, Your Honor.
Okay, let's do this. Let me pull up. You can have your client to come forward.
Okay, Bertie, could you come up?
Hold on. Yeah, he's not going nowhere. His paperwork is not ready to. Hold on a minute. Hmm. If we try motion in another case. Huh? 22. I don't see no 22 and 23. Okay. Let me go to, let's start on that one at a time. Okay. I'm in cause number 24 CCCR 1123. Oh, I don't see no motions in other case. Okay, got case number on both cases. So we're in cause number 24 CCCR 1122 and cause number 24 CCCR 1123. Both cases are styled the state of Texas versus Bertie Trinice Jones. Ms. Jones, is that your full name?
Yes, sir.
How are you doing, Ms. Jones?
I'm good. How are you?
I'm doing fine, thanks for asking, Ms. Jones. You're represented in your case by your attorney Jack Lawrence. Attorney Lawrence, how are you doing?
Just fine, Your Honor.
And the state is represented in this case by attorney Kyle Gasper. Ms. Gasper, how are you doing?
I'm good, thank you, Judge.
That's good. Now, Mr. Okay, well, this is premature, this first motion. Motion to waive imposition of fine for conviction of certain intoxicated driver's license under Texas Transportation Code 709.001. Okay, so that's premature. We're gonna go to the next motion. It's a motion for DP, let's see. Motion for DPS crime lab to retest blood specimen. Okay.
I think we could solve, maybe save a little time by going directly to the motion to retest the blood draw at a DPS laboratory or laboratory designed to produce accurate results.
Okay, don't put your hand on the bench.
That could,
Mr. Lawrence, Mr. Lawrence, take your hand off the bench. Okay. Now, what is that motion? Because I'm looking at a motion for DPS crime lab to retest blood specimen. You have another,
Your Honor, there's two. One is the one that you're reading, and then another one is motion to retest blood draw at DPS laboratory or a laboratory designed to produce accurate results.
the most recent one has two lines across the top. The most recent of the,
it just must, hold on a minute, wait a minute.
that's the one we should deal with.
Oh, motion to retest blood draw,
Yes,
blood draw. Okay, so we have a resistant arrest and a driving while intoxicated.
yes,
Okay.
Your Honor, and we're
So
mainly looking at
in the driving while intoxicated, there was a blood draw?
Yes, Your Honor.
Okay, so you want the DPS lab to retest
Yes.
the blood that was drawn from her?
Yes, Your Honor, because they discovered there was no alcohol, and then, and here's their report.
Well, this is not an evidentiary matter.
Well,
Only thing we know, I mean, we could, if you need to be retested, so you retested, you want them to retest the drugs, to retest the blood, right?
yes,
Because there was no alcohol in the blood.
right, and here's what happened.
Okay, no, I just need to know. So, hold on a minute, let me look at the information. Hold on a minute, let me go back to that.
The state is now,
Yeah, just hold on, just let me, get to one thing at a time. We'll give you time to talk. Okay, I'm looking at the information. So they just said defendant was intoxicated, that could be by alcohol, drugs, or a combination of both. And I guess, or it could be a current, 08 and above. So that's, okay. So, okay. So you want them to retest the blood,
yes, Your
right?
Honor,
And you want them to retest the blood because there was no alcohol detected. Is that correct?
that's not correct. You are correct in that, in one sense.
In
But
what sense is that I'm correct? Let's deal with that first.
there's no alcohol, so she had no intoxicants, that
No,
they
no,
were
no.
looking, that they arrested her for.
Okay, hold on. I think the law basically states for intoxication, it could be alcohol, drugs, combination of alcohol or drugs, or alcohol, a BAC, a blood alcohol concentration of 0.08 or more.
Alcohol.
Right, alcohol.
Now
So-
they've switched to a drug that barely showed up. Here's the report.
Hold on. Hold on. So you're saying, who switched what? Who switched?
The state is switching its position that that they still have a valid DWI.
Okay, now, do you understand that intoxication doesn't necessarily mean alcohol? It could mean drugs. Right? So you want it to be retested for them to find alcohol?
No, it's phencyclidine, and it even says on the report that further analysis may have to be performed due to the submitted case information. Immunoassay screening indicated the need for confirmation analysis on the phencyclidine, which came in at 0.010, a trace amount.
Okay, so you want them to retest it to see if there's more or less? So I'm.
To see if that's a false positive, because
Oh, okay.
she's prescribed a whole lot of ibuprofen
okay.
every day,
Okay,
and she takes it constantly. And one of the false positives that show up with
Okay, so you just
ibuprofen
see-
is
okay,
phencyclidine.
so you just want them to retest it? Okay,
Retest it and see if the,
okay,
one thing they could look at is the fact that her phencyclidine may be being caused by all the ibuprofen she takes.
okay.
And the state did not know when they did this, that she took all this.
Okay, so, but the issue is you wanted to retest it.
Yes, Your Honor.
Okay, so like I told you, this is not an evidentiary hearing. And state, what's your position? He may be entitled to a retest.
Your Honor, we would argue that this was tested at the time of the offense at a locally accredited lab, and further testing would be costly. Further, defense counsel has provided us with prescriptions for ibuprofen. However, all of the prescriptions that we have gotten from defense counsel before this hearing date almost a year after the original offense. So we have no records that the defendant was prescribed ibuprofen at the time of the offense. So a false positive argument is better, one, better to be placed at trial, and two, we believe that she
Understand.
wasn't on ibuprofen at the time of
Okay,
the
but
offense.
hold on, let's not get into whether she was on or off any type of drugs. At this point, we just need to know whether or not he's asking for a retest. I think he's entitled to a retest.
Yes.
Okay. And so what the court is going to grant the retest. Okay. So that, to anybody print that motion out. It's the last one, it's the last one on the list of motions. He filed it on
To be clear on that order, is that going to be given directly to the agency, or is there something that our office would need to do to make that happen, or is it just going to go from the court directly to them?
well, we normally don't, it doesn't normally come from here. I mean, he's entitled to a retest.
I would think the Austin would be a good place.
Whoever the lab is, they can retest it. Now, let's see.
Your Honor, we ask in that order that it be retested for both drugs and alcohol.
Okay, it's just gonna be a retest. I mean, y'all send in an order to, yeah,
What's the one?
okay, hold on a minute. Retest draw.
Incidentally, they had drawn 2 vials of blood. So it
Let
may,
me do, like I said, the court is not in a position, this isn't, to hear any evidentiary matters. I mean, I think those arguments are,
well, it could-
best for the jury, because you have a jury trial scheduled. Or if you don't have a jury trial, the court, if this is going to be a bench trial, the court is not in a position to hear any evidence unless we're in trial. So at this time, please do not go into any evidentiary matters concerning
this is not
this case.
evidentiary.
Okay, anything about that? I just ordered that the blood is gonna be retested, okay? And so what we're gonna do is move on to the next motion.
Let me mention,
No,
just
don't
just
mention
as a
anything.
practical.
No, okay. We've already, the
You
court has
you'll
already,
understand.
okay, I understand. I understand a lot better than you think. Now, this motion has been granted, okay? And so we're gonna move on to your next motion, okay?
Yes, Your Honor. Let me just.
Now,
talk-
Mr. Lawrence,
Suggest something.
no, Mr. Lawrence, we moving on to your next motion. We finished with this motion. The court has
Yes.
granted the order.
Yes,
You asked for a retest, you have a retest,
yes.
okay? Hold on a minute. Let me, I was looking for that motion. It should be on the second. No, it's gonna click at the. No, you're in the you're in the wrong case. Go to 2-3. Cause they don't have no motions in 2-2. In 2-3, he has both numbers on the motions.
Yes, across the top.
Yeah, but for some reason, they didn't file the motions in the case that ends in 2-2. They filed all of them in the case that ends in 2-3. She hasn't. Cause I'm looking at it right now. And the motion that he's asking for was filed. Okay, let me do this. I'll print it off. Let me print this off. Let me print this.
That's fine.
Let me print this. Okay, I just printed it off. Is that the order attached to that? Hold on.
There's an order attached to it.
Oh, wait. Well, let me do this here. I think they attached the order. Not, that's the motion, the order is right here. I'm gonna print this here. Going to print this. It should be printing right now. I have it. They have the order as a separate document. Okay, notice of hearing, let's see. Motion to compel, you wanna hear that one too? You got a motion to compel?
Yes, there's a
Looking at,
motion to compel. We'll go through it.
okay, let me see, and I come by the attorney. The state to disclose and intangible documentary items to produce inspection. So are you saying that you did not receive discovery? The state has an open file policy and they have a portal that they place all of the discovery items on?
Well, I haven't received all of this.
You haven't received it, so you haven't looked at the portal?
I did get some videos from them and, they could send me on the portal, they could send me as much as they have. Now, you have to
Let me
realize
do
I
this here,
have
let
to
me see.
use. I
Let me
have
do
to-
this here.
I'm
The
not-
state, let me ask the state. Okay, so state, you have, has the state allowed Mr. Lawrence to have access to the discovery portal?
Yes, Your Honor. All discovery access was granted on July 24th of this year, and the media discovery was picked up on July 26th of this year.
Okay, so he has access to the discovery via the portal.
Yes, Your Honor.
Okay,
I can't go in the cloud to get it. I have to go to the Jefferson County site
okay,
and get what's there on in the for the.
okay, let me stop here. What do you mean by you have to go to the Jefferson County site?
I
Is
have.
is that different from the portal? And does it have,
It can be.
okay, well, is all of the discovery material on the Jefferson County site?
They can put it all on.
I didn't say can, I'm asking you, is it on there? Not if it can be placed on there.
I don't think it is in this case.
Well, they don't, and the reason why it's not on there is because they put everything on the portal, is that correct?
Yes, Your Honor.
And that's what all the attorneys, that's how they get their discovery, through the portal, is that correct?
I can't get things through the cloud. I have to go through the website.
And if it helps, it looks like Mr. Lawrence's view discovery.
Yes, Your Honor.
In the DWI case,
Oh, he has?
as recently as August.
Yes.
Oh, so y'all can see whether or not somebody has viewed the discovery?
Yes. Your
He
Honor.
does, okay.
I have some discovery from this case,
Well, they say that you have viewed the discovery as late as August.
probably so. Probably so. But I cannot get things that are in the cloud.
I don't understand. Are you saying that some things in the cloud, some things not in the cloud? I don't understand that.
There you go, there you go, seems to be the case. My computer will not get things that are up in the cloud. The stuff I get has to come through on the
Let me ask the state this
website.
question. Is there any way you can download the discovery material and provide him a copy of it? Is it possible? I don't know how it works.
It's possible. I mean, it would be a task, but it's something that's doable.
Okay.
Yes.
Okay, so if it can be downloaded, what they're going to do is download the discovery material that's in the portal. And so you can pick it up from the DA's office. You just have to make an
Okay.
appointment with them to
That's good.
get it,
That'd be
okay?
good.
I'll give you the flash drive and start doing that.
Okay, thank you.
Okay, okay, all right. Now, will that take care of this motion? It says
Okay,
motion to
I'll tell you
compel
that-
all evidence favorable to now this is a Brady motion. You're looking at the same motion that I'm looking at?
Motion to compel?
It's a motion to compel disclosure of all evidence favorable to the defendant. That's the title.
Yes, and on that motion, we can omit number 5
Okay, hold on, let me get to number 5.
and number 13.
Oh, you already scratched through number 5.
Yes.
And now
But not number
13.
13, we can omit number 13 for the, also.
There's also reports of any scientific tests or experimental studies made in connection with the instant case. Okay. Let me see. Hold on a minute. Okay, so we omit 5 and 13. Okay. Now, let's see, I'm pulling up your case one at a time. Let me see, that's the motion up there. The motion in limine, you say that for trial, right?
Yes, Your Honor, and I probably wouldn't need one if we don't have a jury.
Okay, let's go to let me see, I'm trying to go to the next page. Okay, this is a motion for DPS. Let's see what that says.
Your Honor, I believe that's the other retesting one.
Oh, it is motion DPS crime lab to retest blood spec. Is that
We've already ruled on the retest motion.
yeah, so I mean, you it seems like you have more than one. It's basically the
I had
same.
one I had filed early,
That's this one, okay,
then I realized that there was something I left out,
So
and
you
I came
amended
back and refiled it.
okay.
So the one you granted is good.
Okay, hold on, motion. I'm gonna say motion DPS. Oh, that's withdrawn. Withdrawn. And, okay. Let's go to the next one. Motion for, let me see, motion to waive. Motion to waive imposition, oh, that's the one that was premature.
Yes, Your Honor.
Okay. Okay, let's go to the next one. Order, motion for notice. Let me see what that is. Okay, motion for notice. Okay, definitive attachment. Court to instruct the prosecutor to give in proper form timely notice for proposed use of evidence. Oh, that's, extraneous evidence. Okay. Okay, written notice for full complete. State intends to 108. Okay, let's look at this here motion. The motion for notice. Yeah, that one.
Yes.
Yes, sir.
And then I think he's looking for, I guess, extraneous offenses in intent to introduce evidence in cases of any crime, wrongs, or other acts alleged committed. Okay, that's extraneous. He's asking for notice to be given for Rule 404B.
Yes.
Well, the court will grant that. Let me see, there's this one, granted.
Your Honor, I just want to place notice on the fact that this case is not yet set for trial. So we won't know when the.
No,
10
he
days
just,
is there.
it just is basically saying 10 days before you should give him notice.
Okay,
He's entitled to it. Okay. Let's see, number 2, written notice with full and complete copies at least 10 days prior to commencement of trial. In this case, of any records, documents which state intends to offer pursuant to rule. Okay, it's hearsay. Okay, 803, 804, 902, defendant will have a fair opportunity and will prepare to meet and defend against said evidence or investigate other preparation or source of procedures indicate a lack of trustworthiness. Okay. Exceptions, says present state impression, excited utterance, resisting mentals. Now you're asking for notice on it, and that they give you notice of any evidence that they have regarding the hearsay exception, excuse me, in rule, that are listed under rule 803 of Texas Rules of Evidence, and I think you said 804 exceptions to the rules of available witness.
And you'll notice the prayer on page 2 also refers to constitutional grounds,
Where's that?
The prayer on page 2 of the motion also refers to due process and constitutional grounds for everything in the motion.
Okay. A request is essentially effective representation and due process under Article 10, 13, 19 Texas Constitution and 5th, 6th, 14 amendments of the United States Constitution. Okay. And specifically under those provisions of the Texas Constitution and the US Constitution, what is in particular are you asking for?
The right to a fair trial and the right to due process, both under the Texas Constitution and the 5th, 6th, and 14th Amendments of the U.S.
State, you have a response?
Your Honor, we have no objection to a fair trial. However, we have not set this case for trial, so to determine any and all hearsay statements that might be introduced during the course of this trial, we have not gotten to that point yet.
Okay, but if you get to that point, do you have any objections with providing him with the notice?
No, Your Honor.
Okay, so that'll be granted. All right, number 3, Texas Code of Criminal Procedure 3707, written notice. At least 10 days to the commencement of the trial of intent to introduce evidence. We talked about that extraneous offense that goes back to 404B.
The state has no intent of introducing evidence of extraneous
Okay,
offenses.
that'll be granted. And reasonable notice of 609 convictions that have been used to impeach. So if you have any convictions that you may use to impeach,
Once again, we have no intent on.
so
introducing
that'll be
evidence.
granted, that'll be granted as well. And let me see, it was just four in that motion, okay. So that motion is granted. All right, now let me see. Oh, this thing keeps jumping around on me. My computer screen just went white. Man. Damn it. Here we go. Okay, hold on a minute. Come on. This thing is slow. Let's see. So we did the notice. That was the last thing. Now we motion to prohibit. Let's see what that motion says. If any above nine, move to prohibit the admission of any report author expert opinion, testimony under the authority of. If he's been qualified as an expert, he can give an opinion. Okay. So, and now in this motion to prohibit police officer opinion testimony on the reliability, accuracy, and results of standardized field sobriety tests under Rule 702. Okay. So, I mean, if the officer is determined to be an expert, he can get, an expert can give an opinion. Okay, so this one may be premature as well, because if the state put the witness on the witness stand and they're able to lay the proper foundation to establish that the person is an expert, you can't, they are allowed by law to give an opinion. Mr. Lawrence, you understand that?
The if the state places the police officer on the stand, they can.
No, I said if an expert by law is allowed to give an opinion.
Yes.
If the state laid a proper foundation and established that
Yes.
that officer is an expert, they are allowed to give an opinion.
Yes.
So I think that's why I previously mentioned that this motion may be premature, because if the state is unable to lay the proper foundation to establish that the officer is an expert, obviously you can bring forth the motion.
Yes.
You understand what I'm saying?
Yes, Your
So
Honor.
I think that we can entertain the motion at that time.
Yes.
Okay. And of course, you're allowed to take, in a trial, you'll be allowed to take the expert or whoever they're trying to establish as an expert on voir dire.
Let me
You can
just
do that.
mention that if they try to get the arresting officer to testify, he never filled out his DIC 23.
Well,
So
that's problematic, that'll be problematic for the state. Okay,
Yes.
but at this point, we won't make a ruling on this motion because it's premature.
Yes, Your Honor.
So we'll hold that motion
Yes, Your Honor.
until trial. Okay. Let's see, let me go to the next one.
Jay, on these flash drives I'm making, I'm not going to include your discovery request in it because you should already have access to your own discovery request. So I'm just putting stuff in there that's from our file. Is that okay?
And what I get on my computer is very limited.
Yeah, I'm not giving it to you on your computer. I'm giving it to you with this.
Good, good. I'll see what I get when I review them. See what that leaves.
I think we did this motion. Jack, did you file these motions twice?
No, not,
Because I'm looking at this here motion, I think we already
I
heard this
believe some
one.
of them are.
some of them may have been because I used Mike Mueller out at Frank Adams' office, filed them.
Okay, so that, I think
Your
we
Honor,
might have covered the motions, I think. Yes,
Your Honor, one thing I would like to state for the, just for the court's knowledge, it's that we do have a signed document from Mr. Lawrence that he received hand discovery of the file in these of the physical file in these cases
Oh.
on August 15th of 2024. I hadn't seen that until just now.
so he already received the discovery?
Yeah,
No, not all of it.
But they say they have a signed document that said you received discovery by hand.
No, I just received certain documents that they gave me, including the videos.
May I ask what you think is missing from what we've given you?
Well, I just showed you, he didn't fill out the DIC 23 and she also did not sign the DIC 24. That suggests that, he either didn't know what that suggests is he didn't know what to do under the manual with regard to the
Now,
standardized field sobriety test.
but
And
what does that
therefore,
have to do with what we haven't provided you?
hmm?
What does that have to do with what we haven't provided you?
Well, okay, let me just since they found no ethanol, the lab found there was no
now,
ethanol.
okay, let's not get into the facts of the case. I think
I'm not
they
going,
just asking what documents you have received so that they can, decide, or so that they can figure out what documents they need to give you.
okay,
So I think what y'all probably can,
prove, get your documents that show me why the trace amount of phencyclidine.
Mr. Lawrence, do this. You need to probably meet with the prosecutors, show them what you have. They can see what you have, and then they can give you what you don't have, so that your file will be complete. I
That'd be
think
a
that
good
would be the
idea.
simplest way to handle this.
That'd be a good idea.
Okay, so once y'all just sit down, get your paperwork together, they can look through it, and then they can say, okay, this is what he doesn't have, and they can give you what you don't have. And then that'll make your file complete. That's fine with the state?
State has
Absolutely.
no opposition to that.
Okay, so what we're gonna do, we're gonna stop, and I think, if I'm not mistaken, I looked at all the motions, we basically done. Because you know what I think happened? When you filed your motions, your intent was, you had two of each. One copy was gonna go into one file, and the other copy was gonna go into the second file. they put them in one file. Right? So, and we done went through all of the motions, and so that's why I said it was like a duplicate. They were supposed to put it in the first case, 22, and not put them in 23. They put both of them in 23. So we went through those motions.
We've covered everything but one or two.
Well, one of them, the one to prohibit the expert, that's gonna be done at trial. The motion in limine will be done for trial as well.
What
But,
about this one?
What is
Motion
that?
to waive imposition of fine.
oh, that was premature. That's
Okay.
the first thing I said.
All right. All right.
Yeah, okay. So this hearing is complete. And so this will conclude this hearing and calls numbers 24 CCCR 1122 and calls number 24 CCCR 1123.
Can I just mention something? When they drew the blood, they
Okay,
took two
now,
vials.
hold on, Mr. Lawrence. Two things. I'm not kidding you. The reason why I'm stopping you is because of this. Okay, listen. And you once I tell you what I'm giving, once I say what I need to say, then you'll probably understand. Okay. One, you had mentioned that when we talked about the motion in limine, you said there's not going to be a jury trial. If there's not going to be a jury trial, that means there's going to be a bench trial. And if there's a bench trial, that means that I will be the fact finder,
Yes,
right?
yes,
I don't need to hear no facts right now,
yes.
okay?
This-
And so, this is not trial. All of the facts that you need to bring up about this case can be brought up during the trial.
this-
And so we can't get into anything about the facts of this case until we actually go to trial. And so we're not there yet. And so that's why I'm saying, let's not get into the facts. Let's not get, I'm not gonna make no finding on whether or not somebody has this or do not have that.
Mr. Lawrence, if you would like to discuss the facts outside of the judge's presence, I can meet with you for a little bit.
That's fine.
It's just, this is just
No,
something.
no, listen what I'm saying. And I'm telling you this
This is
because,
not a fact that,
no, but it's inappropriate for you as an attorney to bring any facts before the fact finder before we are in trial. That's inappropriate, mate. It's borderline unethical. Okay? And I say borderline because it may be unethical.
this is about they're gonna retest.
Okay,
The
I don't
blood.
need to get into anything about the retest. Only thing the retest has been granted.
Yes, yes.
And so we don't need to talk anymore about the retest, what was in it in the first test or anything of that nature. And so at this time, this hearing is
Okay.
concluded. And you and the prosecutor can, y'all can talk, y'all can go over the discovery that you have and the items that you need to complete your file. So at this time, the court will be in recess and calls number 24 CCCR 1122 and calls number 24 CCCR 1123. Now, the other thing is, if you are intended on having a bench trial, you need to fill out a form that we have that's a waiver of trial by jury. Obviously, the state would have to agree to it. If they're going to, I don't know if they will or not, but that document has to be in the file.
All right.
Okay, so this will conclude these hearings in County Court Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Now, at this time, we're gonna go back to our arraignment docket. There were some cases that some defendants may have not shown up. It should be is that the first, your hand right there where your hand was. No, go to the next stack.
Okay.
This
is it, this is it.
That's it?
This is-
Okay. Okay. Next case is cause number 24 CCCR 1660. Case is style State of Texas versus Flavia Holcomb Flavia Holcomb was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., Flavia Holcomb's name was called by the bailiff at the courthouse door. Flavia Holcomb did not answer. Flavia Holcomb has not appeared in court since the court has been in session. The time now is 2:58 p.m. on today's date of November 12th, 2024. Ms. Bailiff, could you call the name of Flavia Holcomb at the courthouse door?
Yes, sir. No response, Your Honor.
Okay, no answer. Flavia Holcomb's name was just called again at the courthouse door. Flavia Holcomb did not answer. A reasonable time has passed to give Flavia Holcomb an opportunity to appear in court. Flavia Holcomb has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Flavia Holcomb's bond will be forfeited. A warrant shall be issued for the arrest of Flavia Holcomb in cause number 24 CCCR 1660. Next case is cause number 24 CCCR 1050. Case is style of State of Texas versus Stacy Johnston. Stacy Johnston was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Stacy Johnston at the courthouse door. Stacy Johnston did not answer. A reasonable time has passed to give Ms. Johnston an opportunity to appear in court. Has not appeared in court. Ms. Bailiff, would you please call the name of Stacy M. Holcomb at the courthouse door? And the time now is 2:59 p.m. on today's date.
Stacy Holcomb,
No, Stacy Johnston.
Stacy Johnson, Stacy Johnson. No response, Your Honor.
Okay, Stacy Johnston's name was just called again at the courthouse door. Stacy Johnston did not answer. A reasonable time has passed to give Stacy Johnston an opportunity to appear in court. Stacy Johnston has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Stacy Johnson bond will be forfeited. Warrant should be issued for Stacy Johnson's arrest and cause number 24 CCCR 1050. Next
You wanted me to.
Next case is cause number M323710, case is filed the State of Texas versus Myrick Taylor. Myrick Taylor was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Myrick Taylor at the courthouse door. Myrick Taylor did not answer. Myrick Taylor has not appeared in court since the court has been in session. The time now is 3:00 p.m. on today's date. Ms. Bailiff, would you please call the name of Myrick Taylor at the courthouse door?
Marek Taylor. Marek Taylor. No response, Your Honor.
Myrick Taylor's name was just called again at the courthouse door. Myrick Taylor did not answer. A reasonable time has passed to give Myrick Taylor an opportunity to appear in court. Myrick Taylor has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Myrick Taylor's bond will be forfeited. The warrant should be issued for the arrest of Myrick Taylor. And this will conclude the calling of the court's arraignment docket and the pretrial motion hearing docket on today's date of November 12th, 2024 in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.
Let it be known, Judge, I'm in the process of copying both files in their entirety, and I'm going to give them to them today. So if this becomes an issue later, I have given them flash drives with
Okay.
all of that
Okay.
information.